I know that many people are following my progress in the creepy cop search case out of Putnam County, West Virginia, where drug task force police officers were caught on camera illegally searching my client's house. That apparently includes those officers and their lawyers in the pending federal civil rights lawsuit. On Friday, the defendant officers' lawyers filed a motion completely centered on my YouTube channel, requesting an order prohibiting me from ever publishing video deposition testimony of those police officers. Basically, they're requesting court approval for a cover-up. Now, important First Amendment issues are being implicated. Police already have qualified immunity. The one remedy given to us by Congress is to sue them. Now they want to turn that process into something akin to a family court or abuse neglect proceedings, where the government gets to operate in secrecy and without accountability and any exposure at all. The video depositions in the creepy cop search case haven't even been taken yet. They're actually scheduled to be taken here in a few days, this week. I already agreed to postpone them several times already at their request because they were concerned that the FBI was investigating them. So I gave them time to evaluate their situations and hire or consult criminal defense attorneys before they testified. Now they want to testify essentially in secret. Why? Because posting their video testimony allegedly puts them in danger. They went through the prior videos I published on this situation and they cherry-picked the craziest comments they could find. And they presented them to the court in a motion as the basis for why I should forever be silenced from exposing their misconduct. Let's take a look at the actual motion that they filed. All right, as you can see, here is the motion that they filed on Friday, defendant officers' motion for protective order. In that motion, they explain that the defendant officers are currently set for videotape depositions, and then they start to complain. Well, plaintiff's lawyer, John Bryan, operates a YouTube channel under the name Civil Rights Lawyer. His channel has approximately 89,000 subscribers, and he's already uploaded several videos concerning this case to the YouTube channel. September 7th, they state that they sent me an email, which they did. So they sent me an email asking me to agree to never, ever upload or otherwise publish video depositions of these defendant officers. So obviously I said no. And then they include our emails as exhibits and all of this stuff. So they have our emails back and forth. If you're interested in this whole document is going to be posted up at the website at thecivilrightslawyer.com. Here they continue to complain here. Mr. Bryan began publicizing this case on January 15th of 2020 when he posted a video to his YouTube channel titled Caught on Video. The Putnam County, West Virginia Sheriff Department Special Task Force breaks into a house. Currently has 135,243 views and counting. February 22nd, there's an update video titled Putnam County, West Virginia Creepy Cop Search Video Update. That currently has 132,000 views and counting, apparently. Now I make an appearance in a motion in a pleading in federal court, which is a first, I think. But there I am, a screenshot of one of those videos, July 22nd, 2022. Gee, we fast forwarded like 2 years now. Mr. Bryan posted a 13-minute long video update on my creepy cop search case in Putnam County, West Virginia. This video has currently 222,000 views. Here they get into the comments, okay? Now this is just bizarre. Many comments on these videos are concerning and underscore the need for a protective order governing the use and prohibiting the publication of the defendant officer's deposition testimony. For instance, some comments contain thinly veiled threats of violence against the defendant officers and law enforcement generally, along with suggestions that viewers go to the officer's home. So they screenshotted, and the funny thing is with YouTube, because people can give a thumbs up or a thumbs down to comments, we're talking about hundreds or thousands of comments in some of these videos, and they're finding some that must be way, way, way down that you'll never see unless you scroll for like 10 minutes. Or here's one with no thumbs up, one with 4 thumbs up, one with 6 thumbs up. So they're going way down the cherry pick for comments, and they're screenshotting those and giving them to the federal court. I don't go through and look for crazy comments and delete them or moderate them in any way. So this was the first I've seen any of these, and you can find obviously all sorts of crazy comments on any social media site. So they are cops though. So if they find a threat made by a social media user, they can go find that person and charge them. In fact, I think I posted a video once of a guy represented who was charged with a felony of being a terrorist for retweeting something on Twitter about the West Virginia governor. So they have that power, and if they haven't gone through here and arrested somebody for it, then perhaps that means that no crime was committed. I don't know. Other comments show that the viewers of these videos reside in Putnam County, West Virginia, where most of the defendant officers continue to work. So yeah, I'm sure. What do you mean viewers? That viewer? They don't say what percentage of viewers. It's going to be an extremely minute percentage. And disturbingly, the viewers have made outright requests for Mr. Bryan to post video depositions of the defendant officers while others seek ongoing updates. Why is that disturbing? Let's see. So now they provide what they think is the legal basis for this. Under Rule 26, the court may, for good cause, issue an order to protect the party or person from, this is what they think this is, I guess, annoyance, embarrassment, oppression, or undue burden or expense. Defendant officers submit that they have made their good cause showing. Mr. Bryan's posting their video depositions to his YouTube channel, which haven't even been taken yet, much less posted to the YouTube channel, will lead to their annoyance and embarrassment, and further will unnecessarily expose them to risk of harm. Mr. Bryan's expressed intent to use the defendant officer's video depositions for YouTube content and presumably to up the number of views per video goes beyond the harassment or mocking condemned in the prior case. Indeed, posting the defendant officer's images and identifying information online puts them, their families, their coworkers, and those around them at risk of harm from the individuals viewing content on the civil rights attorney YouTube channel. Individuals who publicly post comments such as, so I'm not even going to read them all. They don't say who makes those comments. They don't tie it to me at all. They want to hold me responsible for comments, some third party. I have no idea who it is. They want to restrict my First Amendment rights based on comments that somebody else said. So what they're asking for is an order prohibiting plaintiff's counsel or any party in this matter from publishing or disseminating audio or video recordings obtained during discovery in this action without prior permission of the court. So there you go. At the end of every video, I tell you that freedom is scary. Why? Why is it scary? Fear is the tool that tyrants use to subject us and to take away our freedoms over and over again from the beginning of recorded history to the present. Of course, police officers in America, if given the choice, would choose to operate in secrecy. They don't want to be recorded. They don't want to give you their names. They just want yours. Imagine if the government could conceal police misconduct by using general fear of retaliation by members of the public. Rodney King, George Floyd, Eric Garner, and so on. Imagine if those videos and the aftermath were suppressed from the public just due to the police officers claiming that they feared retaliation. In the George Floyd case, imagine a prosecutor or a judge saying, wait a minute, hold on guys, sorry, we're going to have to shut all this down. Someone on social media said something crazy. Officer safety, that's the fundamental principle of a free republic, right? So the public is now cut off from the hearing or from hearing any more about this. This is now a sealed family court proceeding, essentially. That's basically what's happening here. Police officers caught red-handed on video violating the constitutional rights of a citizen are asking to hide their otherwise public record testimony from the public due to their perceived safety concerns based on a couple of cherry-picked social media comments. By the way, these officers, who are allegedly afraid to show their faces to the public, asked a TV news reporter to follow them around Reno 911 style as they gallivanted through the local trailer park. Of course, that was back before they got caught and exposed.
Tonight, a special enforcement unit in Putnam County is making dozens of arrests, and it's all thanks to help from neighbors who are fed up with crime.
Kelly, the special enforcement unit has made 316 arrests just since January.
When it comes to fighting crime, this group can't and doesn't do it alone.
The more people that find out we're out here, the more information we're getting.
They're a group of 4 Putnam County deputies, but together they make up the Special Enforcement Unit. They're not undercover, even though they're not in uniform.
Most people are more relaxed with us when we're out of uniform. They'll sit down and talk to you.
They're out driving the streets of Putnam County every day, checking on tips called into the agency's anonymous drug tip line. Just recently, the group became deputized to work with the United States Marshals Cuff Task Force.
The Marshal Service, not only do we go with them, but they're willing to come to our county and serve warrants as well.
Since their formation, hundreds of arrests have been made. They've captured accused heroin dealers, uncovered drug operations, nabbed fugitives, and all with your help. Proactive policing made possible by those who don't want crime in their neighborhood.
Moreover, after I first exposed the video of these officers illegally inside my client's house, it put an end to their unconstitutional activities immediately. It sparked an investigation. The then sheriff issued a public statement informing the public that there would be an investigation into what they did, into the release of this video, into what is shown on the video, rather. We participated in this investigation and provided the raw video footage to investigators. I allowed them to interview my client. Then nothing happened. There was no conclusion provided to the public. Instead, months to years later, I would get a copy of that report entirely marked confidential, where it remains today. That internal investigation report completely exposes these officers. But the public can't see it because the government wants to hide it. We wait and wait and wait, no report, nothing. So not being able to wait any longer, we filed the lawsuit as we're entitled to do. At least we get now, after we filed the lawsuit, and get to that point to take their depositions and to force them to testify under oath. Hundreds and hundreds and hundreds of police officers and other government officials have had to do this in the past. Even Bill Clinton had to do it. You've probably seen that footage. But these police officers think they're special. They already escaped criminal prosecution for what they did. Did they not commit burglary or some other crime by knocking in my client's air conditioner, climbing in through the window, going inside and going through all of my client's stuff without any legal basis for doing so? State and local law enforcement did nothing. The FBI did worse than nothing. They actually tipped the defendant officers off that I, a jacklegged lawyer, had a video showing them in my client's house. People in the government responsible for protecting us did nothing. Absolutely nothing. Only I have done something, and now they're trying to stop me. I have a bunch of colleagues in the civil rights and constitutional law community who are helping me prepare a response to this because it's nuts, and it's in the works. Meanwhile, the depositions are set for this week, and they're going to happen. I've already agreed not to publish them prior to a ruling or even the jury trial in this matter, if that makes them happy. But it won't. They want to silence me and others like me because they don't want you to hear the truth. Gathering information about government officials in a form that can be readily disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of government affairs. That's from a U.S. Supreme Court case in 1966, also cited by the First Circuit case of Glick versus Cunif. Recording police activity enables citizens to keep them honest, an undertaking protected by the First Amendment. That's from Garcia versus Montgomery County. And that's what this is all about. As always, thanks for watching, and you'll find more information in the link below to the blog at thecivilrightslawyer.com. If you have a video you want me to see, please use the submission link in the description or at the blog. If you want to learn more about these cases, about your constitutional rights, please subscribe and hit the bell notification so you don't miss important future videos. Please also comment with your thoughts about this case. Should I be stopped from showing you the video deposition testimony of these officers or other officers? If so, does that apply to all police officers in general? If you want to support the channel, please consider clicking the join button, becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. I'll see you next time.